Good evening, class. Tonight we will continue with our lecture on the law on obligations. Our source material for this lecture will be Obligations and Contracts by De Leon and De Leon Jr. So let's begin with Chapter 2, the nature and effects of obligations. Pero bago tayo magsimula dyan, remember, we first have to identify and differentiate kung ano yung mga specific and generic objects para mas lalo tayong magkaintindihan. So anyway, specific objects or sometimes known as your determinate objects, pareho lang yan, they are the same animals. So they are objects which are particularly designated or physically segregated from others of the same class. It is identified by its individuality. So, remember also, pagka specific or determinate object, pwede mong masabi na ito ay unique. Kaya wala siyang kapareho sa mundo. Now, the rule is that the debtor cannot substitute a specific or determinate object with another object. Bakit? Kasi iba na yun sa usapan. Kung ito yung specific object, kung papalitan mo siya ng ibang object, hindi na yun. That is out of the question already. Kasi hindi yun ang pinag-usapan ng mga parties. Kahit na magkapareho sila ng itsura, magkapareho sila ng quality, magkapareho sila ng quantity, etc. etc. Kahit na magkamukhang magkamukha. But remember here, pagka-specific object, yung mismong object na yon ang dapat i-deliver. It cannot be substituted. However, the exception happens when there is consent of the creditor. Now, let's take for example, an obligation to deliver a car. So, sige, dun muna tayo sa object muna. The object is a car. So, the obligation here is a real obligation to deliver a car. So, let us say, ikaw ang debtor. So, remember, the debtor has a duty to perform a determinative conduct, like I've said before. Now, yung creditor, siya yung merong right to demand performance of an obligation. So, here, the creditor demands for a car. Doon muna tayo sa car. So, car, by itself, remember, cannot be considered a specific object. Bakit hindi po specific yung car? Kasi ang dami-daming car. Hindi siya unique. Ang daming kotse. Now, let us say a red car. Now, pagka sinabi kong red car, pwede na bang masabi na ito ay specific? Again, hindi pa rin. Kasi tumayo ka sa harap ng TSU, tingnan mo kung gaano karaming red car ang dadaan. So, again, hindi na naman siya unique. What else? Now, what if binigyan ko pa rin ng qualification a red Toyota Vios car? O ba, meron na siya ngayon Toyota. Tapos meron pa siyang Vios. So, meron na siyang make, meron na siyang model. So, red Toyota Vios car. Now, is it already specific object? Remember here, class, na hindi pa rin. Bakit na naman hindi pa rin specific or determinate object yung red Toyota Vios? Again, tumayo kayo sa harap ng TSU. Tingnan nyo kung gaano kadami ang pulang Toyota Vios na dadaan. Again, marami na naman. So here, the object is not identified by individuality. It is not unique. Hindi pa siya specific. Now, what if I say a red Toyota Vios with plate number ABC123? Remember, that is already a specific object. Bakit? Nag-iisa lang yun eh. Wala kang makikitang red Toyota Vios na dalawa na pareho yung plate number. Bawal yun, remember. So here, the object is designated by its individuality. Unique. Nag-iisang sasakyan lang yan na may plate number na ganyan. Na may make and model na ganyan. So remember, specific na yung object. Now, here, pagka ang obligation is to deliver a red Toyota Vios with plate number ganito ganyan, ABC123, ang kailangang i-deliver ng debtor is yung ABC123 na red Toyota Vios. Now, pwede bang mas mahal na sasakyan, na klase ng sasakyan ang i-deliver? Let us say, a Jaguar or kung ano pang sports car. Pwede bang yun ang i-deliver? Of course not, class. Bakit? Kasi ito ang pinag-usapan ng object. The debtor cannot substitute it. Kahit na ibang Toyota Vios na pula, pero iba yung plate number, hindi pwede. Kasi it is not the very object that is talked about. Hindi yun ang pinag-usapan. Ang pinag-usapan natin yung plate number na ABC 123. Mas mahal pa yung sasakyan, hindi rin pwede. Kahit lalo na kung mas mura pa yung sasakyan, lalong hindi pwede. Unless there is consent of the creditor. Specific, unique, yun ang specific or determinate object. Now, what about your generic or indeterminate object? Remember, a generic thing, when it refers only to a class or genus to which it pertains and cannot be pointed out with particularity, identified only by species. So, usually, ang mga example sa generic car, syempre, maraming car, class or genus, ayun, car, period. Toyota Vios, yun lang, class or genus. So remember, it is not, cannot be pointed out with particularity. Usually, binibigay na example dyan, sack of rice, sack of sugar, sack of corn, ganyan ang mga example sa book ninyo. But of course, pwede naman kayo magbigay ng ibang example. Like a carabao, yan. Yun ay isang generic object kasi marami namang kalabaw. Paano magiging specific ang carabao? A carabao named Muning, yan, pwede. So, yung carabao na si Muning ay isang specific object na. Pero kung sinabi mong carabao lang, ito ay generic object. So, remember, the debtor, in case of a generic real obligation, can give anything of the same class as long as it is of the same kind. So, basta pareho. Kung ang pinag-usapan ay kabayo, basta kabayo. Kahit na anong klaseng kabayo, basta kabayo. Same kind. So, yun ang tandaan natin sa specific and generic objects. Now, dun muna tayo sa specific real obligations. So, ano yung specific real obligation? Common sense. It is an obligation to give, kasi nga real, di ba? Remember, real is to give. Obligation to give a specific object. Yun ang specific real obligation. So anyway, these are the duties of the debtor in case of specific real obligations. Number 1, the debtor has a duty to preserve the object and to exercise diligence. Now, what kind of diligence must be exercised? Yung diligence of a good father of a family. So, yun yung diligence which is required by prudent persons. So remember yung diligence of a good father of family, sometimes known as your ordinary diligence, is yung diligence na ina-exercise ng average or reasonably prudent person over his own property. So yun ang kailangan na klase ng pag-aalaga na ibibigay natin sa isang specific object pending delivery. So obviously, bago mo i-deliver, let us say, specific car, you will deliver in 2 days. While hindi pa dumarating yung date ng delivery, you have to take care of the car, obviously. And what kind of diligence will you use? You will use, remember, the diligence of a good father of family, or otherwise known as the ordinary diligence. Now, pwede namang mag-stipulate or mag-usap ang mga parties to use another standard of care. So, pwedeng extraordinary diligence. Ibig sabihin yung sobra-sobrang pag-iingat, exage na. Or pwede namang slight diligence, yung petiks-petiks lang. Pero remember, the parties cannot agree that there is exception from the exercise of diligence. Bawal na sabihin na magkakaroon ng, bawal sabihin na walang pag-iingat. Bawal mag-stipulate ang parties na walang pag-iingat na i-exercise when it comes to the taking care of object. So, usually naman yung diligence will correspond to the circumstances of person, of time, and of place. So, yun ang standard of care na ginagamit ng isang tao para sa protection ng kanyang property. So, yun ang tandaan natin dyan. The next duty is the duty to deliver the fruits of the thing. So, if you will deliver a horse, ano yung fruit niya? Yung kanyang mga offspring, yung kanyang anak. So, anak ng kabayo. So, yun ang tandaan nyo. So, creditor will have the right to the fruits from the thing, from the fruits of the thing from the time the obligation to deliver it arises. So, kung oras nang i-deliver yung primary object, yung principal object, obviously, pati yung fruits meron ng, pati yung fruits, obliged na yung debtor to deliver yung fruits. Remember also here that the creditor will have no real right over the fruits until the same has been delivered to him. Please take note also of the kinds of fruits. So remember, natural fruits, industrial fruits, and civil fruits. So natural fruits are spontaneous products of the soil and the young and other products of animals. Katulad nga nung sinabi ko kanina, ang kabayo, yung kanyang anak, natural fruit yon. Also, yung mga bigla na lang tumutubo sa soil, yung mga bunga ng fruit-bearing trees, yun ay mga natural fruits. Now, industrial fruits, those that are produced by lands of any kind through cultivation and or labor. So, ito yung mga tinatanim pa, sinasaka yan. So, yung mga, remember, yung mga bigas, etc. Basta yung merong labor involved, mga bigas, bigas naman yung tawag dun, no? Pagka hindi pa niluluto. Tapos pagka naluto ng kanin, anyway, they are industrial fruits. What else? Civil fruits, they arise out of juridical relationships. So, ang mga civil fruits, remember, ang example niyan is yung interest and yung rentals, ganyan. So, yung interest, remember, it arises from a juridical relationship between a creditor and debtor. So, yun ang juridical relationship ng creditor and debtor. Ang tawag dyan, a contract of loan or mutuum. Simple loan or mutuum. Yan ang tawag dyan. So, in case naman of rentals, it will arise because of the juridical relationship of lease or yung pangungupahan. So, remember, the juridical relationship will arise between lessor, yung nagpapaupa, and lessee. So, yun ang rental. So, yun ang mga civil fruits. Marami pang ibang klase. Binigyan ko lang kayo ng dalawang example. So, obviously, the creditor will have a right to fruits from the time the obligation to make delivery arises. So, what else do you have to remember? Yung obligation to deliver fruit arises when? Number 1, general rule ito. The obligation to deliver the thing due and consequently also yung fruits arises from the time of the perfection of the contract. So, yung perfection ng contract, ito yung stage ng isang contract na nagkaroon na ng agreement between the parties. So, they agree on the object usually and they agree on the price kung there is a sale involved. So, pagka nagkaroon na ng agreement dun sa mga details ng contract yan. So, napag-agreehan na nila yung object, napag-agreehan na nila yung price, etc. Meron ng consent nun. So, pagka nagkaroon na ng tatlong elements, cause, object, and consent ng isang contract, the contract is perfected. So, pagka perfected na yung contract, the obligation to deliver the thing due and including the fruits arises already. So, kung nagkaroon na ng agreement o i-deliver mo itong specific horse na to. So, itong araw na itong oras na to, nag-agree tayo na i-deliver ko yung specific horse na to. So, kailangan kong i-deliver ngayon upon perfection of the contract kasi nagkaroon na ng agreement, bigay ko na ngayon, and also including the fruits of, if any, noong specific object. Now, what else? What if the obligation is subject to a suspensive condition or period? So, yung suspensive condition or period, malalaman nyo lang yan when we discuss Chapter 3, the kinds of obligation. Basta, kailangan nyo lang tandaan, yung suspensive condition or period, yung suspensive condition, kailangan mangyaring condition bago magkaroon ng obligation. Yung suspensive period naman, kailangan mag-arrive yung period so that there is an obligation. So, obviously, yung obligation to deliver the fruits will arise only pagka nangyari na yung condition or pagka nag-arrive na yung term. So, anyway, we will discuss more of that when we go to Chapter 3. Basta, ang suspensive, may condition, may obligation, pagka nangyari yung condition na yan, magkakaroon ng obligation to deliver the fruits. Pagka naman suspensive period, pagka nag-arrive yung period na yan, magkakaroon ng obligation to deliver the fruits. What else? Number 3, in case of a contract of sale, remember, the obligation arises from the perfection of the contract, even if the obligation is subject to a suspensive condition or a suspensive period where the price has been paid. So, pagka ang contract is a sale, tapos pagka ang binenta nyo is, halimbawa, again, aso na lang para mas madali. So, yung aso ninyo, let us say, ang pangalan ng aso nyo is Tick Boy. So, hindi, Tick Girl na lang para may anak siya. So anyway, so itong si Tick Girl na aso ninyo, specific yan kasi nga may pangalan pa siya eh. So nag-iisa lang si Tick Girl. So the delivery of the object is subject to a condition or a period. Sabihin na lang na suspensive period na lang para mabilis. 2 weeks. So yan ang suspensive period. Deliver Tick Girl in 2 weeks. Tapos binayaran na si Tick Girl. So, i-deliver mo bilang debtor in 2 weeks. The obligation is subject to a suspensive period. So, kailan mo talaga i-deliver yung object? Pagkatapos nung 2 weeks, dun sa pagka-arrival of the period. So, pagka nag-arrive na yung period, dun mo i-deliver si Tick Girl. Now, what if there are fruits? In the meantime, nanganak si Tick Girl. Yan. So, yun ang tandaan, yun ang pag-isipan nyo. Remember, here, the rule is that since the price has already been paid, kahit na hindi pa na-deliver si Tick Girl, remember, yung fruits ni Tick Girl or yung kanyang natural fruits, yung mga anak niya, is supposed to go to the buyer noong aso. So, that is the rule in a contract of sale. Otherwise, kung hindi bayad, it will belong to the seller. So, that is what you have to remember. So, even if the obligation is subject to a suspensive period, because kahit na hindi pa nag-arrive yung period, but because payment has already been made, remember, buyer is entitled to delivery of the fruits of the principal object, which is the dog. In obligations to give arising from law, quasi-contracts, delicts, and quasi-delicts, remember the time of performance will be determined by the specific provisions of law. So, let us take for example na lang law. Remember, ang mga obligations arising from law is immediately due without need for demand. Like the obligation to support your children. So, wala nang deadline dyan. So, ang support ng children is immediately demandable kasi yun ang sabi ng law. That is the specific provision provided by law in the family code. So yun ang tandaan nyo in case of obligations to give arising from law, contracts, quasi-contracts, delicts, and quasi-delicts. Also, please take note of the third duty. It is the duty to deliver accessions and accessories. So yung pagka meron kang i-deliver na specific object, remember that you have to include also the accessions and the accessories of the object na i-deliver mo. So, even if the accessions and accessories are not mentioned in the agreement, automatic yan. You have to include them. Now, ma'am/sir, ano ba yung accessions and accessories? Remember, accessions, they are fruits of a thing or additions to or improvement upon the principal object. So, usually, ang example nito is yung whatever is built, planted, or sown on a person's parcel of land. So, yung bahay na may binebenta kang lupa, tapos merong bahay na nakatayo, obviously, kasama yung bahay sa binibili mong lupa, being an accession to the land. Let us say, bumili ka ng building. Obviously, kung merong mga nagre-rent dun sa building na yon, yung mga rentals na makukuha, or yung rentals na makukuha, accessions din yung mga yan. Fruits of a thing nga eh. Diba? Remember, your rentals are industrial fruits. What else? In case that you are buying shares of stock, obviously, yung dividends accruing to the shares, kasama din yan doon sa stocks na binili mo. What else? Yun namang accessories. So yung accessories naman, those which are joined to or included with the principal thing for the latter's embellishment, better use, or completion. So, ang example nito, usually, susi sa bahay. So, para nga naman madaling pumasok sa pinto ng bahay. Better use or completion. What else? Bracelet of a watch. So, meron kang relo, wala namang bracelet. So, hindi naman siya kumpleto for completion. Mas madali sigurong gamitin ang relo na mayroong bracelet. What else? Machinery in a factory, dishes in a restaurant. So these are examples of accessories. So in your car, sa palagay ko sa mga kotse ninyo, kung nagbenta kayo ng kotse, siguro yung kasama na dapat dun yung stereo, siguro. Siyempre, mas maganda naman yung sasakyan na may stereo, etc. etc. Kailangan kasama itong mga bagay na ito. So, yun ang accessories. Now, the rule is, pagka nag-deliver kayo ng principal thing, all accessions and accessories are considered or deemed included, although they may not have been agreed upon. Wala naman tayong pinag-usapan na kasama yung bahay eh. Hindi. Basta nakatayo yung bahay dun sa lupa na binenta mo, matik kasama yung bahay. Kasi yun ang rule. Accession yun eh. So it is included. This rule is based on the principle accessory follows principal. So tandaan nyo mabuti yun. Accessory follows principal. So the principal object here is the land. The accessory is yung halimbawa, yung lupa, ganyan. So, ay yung bahay pala. So, yun ang accessory. So, yun ang pinakatandaan ninyo. Now, ma'am, sir, paano kung ayaw ko talagang ibenta yung bahay? Pwede naman, yes, but remember, there must be an express stipulation to that effect. So, dapat meron kayong usapan na ay lupa lang, di kasama yung bahay. So, yun ang tandaan ninyo sa accessions and accessories. The general rule is kasama. To exclude them, there must be an express stipulation. Parang ano yan, gulong ng kotse. Pagka bumili kayo ng kotse, kasama yung gulong, obviously. Para sa completion, di accessory yan eh. So anyway, kung hindi kasama yung gulong, pag-usapan nyo, hindi kasama yung gulong kuya ha. So yun ang tandaan natin sa accessions and accessories. What else? Duty number 4 is the duty to deliver the object itself. So, obviously, inalagaan mo, dineliver mo yung kasama yung fruits, kasama yung accessions, accessories. Obviously, kailangan mo rin i-deliver yung mismong object. Yan. So, every person obliged to give a specific thing must deliver, and the creditor may compel. So, pwedeng ipilit ng creditor yung delivery ng pinag-usapan. And also, remember, the creditor cannot ask for a different thing. And also, the debtor cannot substitute the thing promised. So, yun ang tandaan natin. So, pwede lang magkaroon ng substitution if the creditor agrees. Now, please take note also of the rule as to when the obligation to deliver arises. So yung kanina, when the obligation to deliver fruits arises. Kanina pinag-usapan natin fruits. Ngayon ang pinag-usapan natin is yung mismong object. If there is no term, walang period, walang condition from the time of perfection. So perfection again, nagkaroon ng agreement sa parties, deliver na. Yan. What else? Kung meron namang term or period or condition, period is otherwise known as term. So, then from the moment the term arrives, pagka dumating na yung period na stipulated or the condition happens, that is the time to deliver the object. So, yun ang tandaan ninyo sa delivery. Anyway, we will study the kinds of delivery when we go to sales. So, maraming klase ng delivery. Doon ko na lang i-discuss yun. So, anyway, duty to answer for damages in case of non-fulfillment or breach. So, if there is fraud on the part of the debtor, negligence, delay, or contravention of the tenor of the agreement, the debtor is liable for damages. Kasi nga, nagkaroon ng non-fulfillment, hindi na i-deliver yung object, nagkaroon ng breach of contract or failure doon sa part ng debtor. So, yun ang tandaan natin sa specific real obligations. Now, about the duties of a debtor in generic real obligations. So, again, ang generic real obligations is the obligation to give generic objects. So, pasok na naman ang inyong isang sakong bigas, isang sakong asukal, etc., etc. So, the duties of a debtor. Remember, class, the creditor may ask that the obligation be complied with at the expense of the debtor. So, creditor may demand from the debtor, comply with your obligation. So, obviously, this is an obvious duty. What else? If the thing to be delivered is indeterminate or generic, the debtor must deliver a thing of the quality specified or intended by the parties. So, kung high quality or superior quality or average quality or low quality, kung ano yung napag-usapan. Ang napag-usapan is high quality ng isang bigas. So, high quality rice, yan ang i-deliver. Because yun ang napag-usapan, yun ang i-deliver. Ma'am/sir, what if wala pong napag-usapan? Punta tayo dun sa rule of medium or rule of average. What you have to deliver now is an object of average quality kung walang napag-usapan. So, kung napag-usapan, low quality, edi low quality ang i-deliver mo. Yun lang naman ang napag-usapan. Kasi yun ang intention ng parties. Now, again, kung walang napag-usapan, deliver average quality. Now, what you have to remember is that if there is no agreement as to quality to be delivered, average ang i-deliver, di ba? Kasi nga, yun ang rule of medium, rule of average. Now, the creditor cannot demand an object of superior quality. And the debtor, syempre, cannot deliver a thing of inferior quality. So, that is the rule in 1246. Madadaanan natin uli yan. What else? Again, to be liable for damages in case of fraud, negligence, or delay in the performance of the obligation or contravention of the tenor of the obligation. Same duty in case of specific real obligation. Siyempre, pagka may breach, laging may liability for damages according to 1170. So, yun ang tandaan muna natin. How about the remedies? So, yung remedies in real obligations, in case of breach of real obligations, what you have to remember is that kailangan yung i-differentiate. Ano ba yung binibreach? Specific obligation or generic obligation? So, for specific real obligations, the the remedies of the creditor, syempre remember class, ang creditor ang may right. Ang nagbi-breach ng contract is yung debtor. So, the law provides for remedies to the creditor. Siyempre, siya yung may right na mag-demand. Hindi niya makuha yung kanyang demand. So, ito yung remedies. Specific performance or fulfillment of the obligation with a right to damages. So, go to court. The court will order the debtor to perform the obligation or to deliver the object. Specific object. So, yun ang tandaan nyo. Ang specific performance is an action in court because only the court can compel delivery ng mga objects. Alangan namang pilitin nyo yung debtor, tututukan nyo ng baril, etc., etc., tatakutin nyo na babarilin nyo siya or papatayin nyo yung pamilya. Bawal yun. So, go to court. The court can legally compel yung debtor to deliver a specific object. And you can be entitled to damages as well. The creditor can also demand rescission or cancellation of the contract in some cases and also with the right to recover damages. We will learn more of this as we go along our course, and demand payment of damages when it is the only possible remedy. So, yun ang tandaan natin sa remedies ng specific real obligations. In generic naman, creditor can demand compliance with the obligation. Now, if the debtor fails performance by a third person. So, kasi nga, dahil nga generic lang ang object, pwedeng i-deliver ng iba yan. Pwedeng iba ang magbigay. Like isang sako ng bigas, dapat i-deliver ni debtor. Ayaw i-deliver ni debtor or debtor failed to deliver. Mag-order ka sa iba. But remember here, at the expense of the debtor. So, debtor ang magbabayad. Creditor can even recover damages. So, yun ang tandaan natin sa remedies in case of generic real obligation. So anyway, also please take note of bad faith or delay on the part of the debtor. So yung bad faith on the part of the debtor is delay is obviously delay na hindi niya na-deliver on time after demand has been made. So yun namang bad faith is promising to deliver to separate creditors the same thing or object, same specific thing or object. So, inalok mo kay A itong specific car na to. Tapos sabi ni A, sige, inalok mo kay B itong specific car na to. Same specific car. So, remember, there is bad faith on your part. Tapos, hindi mo ma-deliver, you are liable for breach. So, anyway, in case of a fortuitous event, liable pa rin ang debtor. So, anyway, pag-aaralan natin lalo mamaya yung effect ng isang fortuitous event sa isang obligation, whether it is generic or specific. Mamaya matututunan nyo rin yan, lalong-lalo na itong doctrine na to. Doctrine na genus non quam perit. Yan. Doctrine, genus never perishes, genus non quam perit. Other books I see peruit, merong U. So, anyway, ano natin yan. Pag-aralan natin mamaya-maya. So, let's talk about personal obligations now. So, ano yung personal obligations? Again, it contemplates service. So, pagka ang gagawin is service, remember, real obligations to give. Personal obligations, service, to do or not to do. So, yun ang personal obligations. So, anyway, the stipulations contemplated, ito yung pinag-uusapan sa isang personal obligation. Remember, what we are talking about here is breach. So, the debtor fails to perform an obligation to do. Hindi niya ginawa. Pintura ka ng bahay na to. Hindi siya nagpintura. Debtor performs an obligation but contrary to the terms. Pinturahan mo itong bahay na to ng kulay pink. Yan ang favorite color ko eh. Pero pininturahan mo ng violet. So, contrary to the terms. What else? Debtor performs an obligation to do. Yes, pinerform niya. But in a poor manner. So, pangit yung pagkakapintura. Oo, pininturahan nga niya ng pink, pero pangit yung pagkakapintura kasi let us say, ang ginamit niya, imbis na paintbrush, ginamit niya toothbrush. So, ganun ang pinapintura niya. So, here, the debtor performed the obligation but in a poor manner. So, how about the remedies in personal obligations? Kanina, pinag-usapan natin yung remedies sa real obligations. Now, in personal obligations, the rule is that hindi ka pwedeng mag-file ng action for specific performance. Remember, an action for specific performance, I told you a while ago, is go to court. The court will order the debtor to deliver the object. Now, here, paano kung ang obligation is personal? Pwede bang pilitin ng korte na magpintura yung obligor doon sa bahay? So, remember, pagka personal obligations, the court cannot compel yung debtor obligor to perform yung isang personal obligation because this is like involuntary servitude or pinipilit mo siyang pangaalipin, ganyan, involuntary servitude. So, This is prohibited under the Constitution. Yung sapilitang paggawa ng bagay na ayaw mo, sa pilitang paggawa ng bagay, mag-aral. Feeling nyo naman, involuntary servitude yung pag-aaral. Huwag nga kayong OA. Anyway, voluntarily, you enrolled in this class. So, ginusto nyo to. Ginusto nating lahat ito. I accepted this teaching assignment. So, ginusto ko rin to. Kahit na hirap tayo sa online class, sige, kaya natin to. Basta, bahala na. Pagka nag-board exam, bahala na. Basta ang style natin dito, class, is I'm teaching you to be prepared for the board exam. Whatever it takes. Kasi, sayang naman kung hindi nyo makukuha sa one take. So anyway, pagkatandaan nyo to, habang nag-exam kayo, maririnig yung boses ko. Pagka personal obligations, bawal ang specific performance. Anyway, the obligation can be performed by a third person at the expense of the debtor/obligor. So, yun ang tandaan nyo. Huwag yun ang pilitin yung debtor/obligor kung ayaw niya. Bawal sa Constitution yan, involuntary servitude yan. Anyway, a third person can perform, debtor will pay plus damages. What else? In case of personal, sabi ko, i-discuss ko sa class. Anyway, in case of personal qualifications of the debtor, are the determining motive for the obligation contracted, and in case the performance of the same by another person or a third person is impossible or it is different. So obviously here the obligation cannot be performed by a third person. The only remedy of the creditor is to ask for damages. Sige na nga, i-discuss ko na dito. Yung personal qualifications of the debtor, let us say kumuha kayo ng isang singer para sa isang concert, benefit concert sa TSU Gym. So, nag-invite kayo ng maraming VIP, tapos kumuha kayo ng napakagaling na singer talaga, sobrang galing para mag-perform doon sa concert ninyo. Benefit concert. So, maraming magdo-donate dyan. So, kailangan magaling yung singer. So, kinuha yung singer, yung pinakamagaling na singer, Coco Martin. So, let us say yun ang kinuha yung singer. So, anyway, nung araw na performance ng obligation, may kontrata kayo ni Coco Martin, so siya yung obligor in the agreement. Tapos, kayo yung obligee. So, anyway, itong si Coco Martin, hindi siya makakarating. Let us say, busy siya sa shooting ng probinsyano. Kasi, nabaril daw siya doon eh. So, anyway, busy siya. So, now, if a third person sings doon sa concert na yun, iba. Kasi, hindi siya kasing galing ni Coco Martin. What else? Remember here, kaya mo kinuha si Coco Martin is because of his, ito, i-underline ko, personal qualifications. Kaya mo siya kinuha. Yun ang determining motive. That is the reason bakit mo siya, napakagaling kasing singer nito eh. So, yun ang kinuha mo talaga. So, if a third person, a different person sings this song, ano ba paboritong kanta nyo ni Coco Martin? Maybe This Time. So, yun ang paborito nyo. So, iba talaga kung iba yung kumanta. So, it cannot be considered as performed. So, kahit nakantahin ng kahit kantahin na magdamag ni Sarah Geronimo yung Maybe This Time, hindi kasing galing ni Coco Martin talaga eh. Different, remember. So, the obligation cannot be considered performed. So, you cannot ask a third person to do it. So, ano na lang ang pwede mong gawin? The only remedy of the creditor is indemnification for damages. Magbayad na lang ng danyos, yun na lang ang hingi niya sa court, damages from Coco Martin. Kasi Coco Martin committed breach of contract. So, hindi ko maintindihan ang dahilan. Laging yun ang example ko. Wala kasi akong alam na singer's class eh. So, anyway, how about if the obligation is negative? So, do not do. Not to do. Pero anong ginawa mo? Siyempre, kung ikaw yung obligor, ang obligation is not to do, siyempre, ginawa mo. You did. Yan. So, anyway, the thing may be ordered undone, provided undoing is possible at the expense of the debtor plus damages. If it is impossible to undo, because there are already rights acquired by third persons in good faith, the remedy is an action for damages. Like sinabi, huwag kang magtayo ng building dyan. Tapos nagtayo ka ng, syempre kung ano yung hindi pwedeng gawin, yun ang gagawin mo, di ba? So nagtayo ka ng building dyan. Tapos meron ka ng mga nagre-rent. So itong mga nagre-rent na to, they are third persons who acted in good faith. Tapos, meron na silang vested rights that were acquired. So, hindi na pwedeng basta-bastang i-undo yung obligation. Hindi na pwedeng basta-bastang wasakin yung building. So, the remedy is simply an action for damages caused by the debtor's violation of the obligation not to. Please take note, class, also of the grounds for liability. So, remember, there are four. Dahil sa mga, if yung mga grounds for liability exist, obviously, the debtor is liable. So, yung grounds for liability, remember, is fraud or deceit, negligence or fault, legal delay or default, and the last one, contravention of the terms of the agreement of the parties. So anyway, let's discuss first fraud or deceit or dolo. Please take note of, again, your Latin terms, dolo. So dolo is the deliberate or intentional evasion of the normal fulfillment of an obligation. So remember, there should be malice or dishonesty, and it does not include yung mga cases of mistake and errors of judgment made in good faith. So pagka may fraud or deceit or dolo, remember, there is also bad faith. There is a design to mislead or deceive another. So tandaan nyo sa fraud, this is very important. Fraud is always intentional. So hindi mo pwedeng sabihin, hindi ko sinasadyang lokohin ka. Dahil pagka nanloko ka, lagi mong sinasadya yon. Yun ang tandaan nyo. So kung sinabi ng boyfriend nyo na, ay sorry, hindi ko sinasadyang i-text yung ex ko, etc. etc. Hindi totoo yun. Walang panloloko na hindi sinasadya. So fraud, remember, is always intentional. Yun ang tandaan nyo. So in the performance of an obligation, pagka may involved na panloloko, always intentional. Sinasadya talaga. Intention niya na lokohin ka. Kaya wag na wag kayong maniniwala dun sa mga nagsasabing hindi ko sinasadya na lokohin. Laging sinasadya ang panloloko. Yun ang tandaan nyo. Fraud is always intentional. Hindi ko sinasadya na makipagmabutihan sa, syempre, baka mamaya mahuli tayo sa YouTube, no? Hindi ko masyado yung mga terms na dapat kong sabihin talaga. Makipagmabutihan sa kapitbahay, kahit na may girlfriend ka na, etc., may asawa ka, sinasadya lagi yun ka. So remember, fraud is intentional. There is malice, kasi nga intentional siya, and there is dishonesty. So, tandaan nyo, yung fraud, deceit, or dolo. Anyway, there are two kinds of fraud. Yung causal fraud or dolo causante. This is fraud employed in the execution of a contract which will vitiate consent. So, vitiated consent, ang ibig sabihin yan is defective consent. Somehow, merong defect yung consent mo dahil sa mga factors na provided by law. So anyway, here, fraud vitiates consent. So, anong ibig sabihin yan? Parang namang hindi ko maintindihan, ganun ka na. So, ang kailangan nyo lang tandaan sa causal fraud, dahil sa fraud, na engganyo ka na magbigay ng consent sa contract. Kung hindi ka niloko, hindi ka papayag sa contract na yan. So, yun ang tandaan natin sa kausante. Kung halimbawa, nagbenta sa'yo ng necklace, sinabi na ginto yung necklace, ang gusto mo talaga is gintong necklace. So, malamang-lamang, kung alam mo na fake yon, hindi mo bibilin. So, ang hinahanap mo is gold. So, ang in-offer sa'yo, bilhin mo na tong gold na necklace ko. So, if it turns out na hindi ito gold, this is, remember, causal fraud. Bakit? Kasi, yung misrepresentation here, the fraud, induced you or inengganyo ka na pumasok sa contract. And had you known that this is not real gold, remember, you would have not entered into the contract, you would have not bought yung necklace. So, remember, ito yung tinatawag na causal fraud. So, vitiates consent. Defective yung consent mo kasi niloko ka eh. Kung alam mo lang na hindi ginto ito, hindi mo siya bibilhin. So, yun ang causal fraud. Causal nga eh. It cost you to enter into a contract. Here, remember, this is a ground for annulment of a contract. So, for now, what you have to remember is that pagka may vitiated consent because of fraud, defective consent because of fraud, the contract is voidable. Tandaan nyo muna tong terms na to, tsaka na lang natin i-expound pagka dumating tayo sa contract. Pagka naman voidable yung contract, remember, it can be annulled. I'm sure aware naman kayo sa term na annulment ng contract. So anyway, yung second kind of fraud, which is the fraud referred to in 1170, is incidental fraud or dolo incidente. So, fraud committed in the performance of an obligation already existing. So, ibig sabihin, yung obligation nandyan na. Walang panloloko before kang pumasok sa contract. So, hindi ka na-induce because of fraud. Here, there is already an existing contract. So, let us say, meron ka na talagang kontrata na bumili ng detergent powder galing sa isang supplier. So, anyway, lagi mo naman kasing lahat ng mga detergent powder, lagi mong binibili sa supplier na to. Tapos, later on, meron isang batch siya na binigay na merong halong chalk. Usually naman sabi nila may halo daw chalk yan eh. Pero ito sobra talaga yung chalk. So may may flour pa. So anyway, so here meron siyang fraud. It happened after the obligation is already incurred. So existing na yung obligation, tapos nagkaroon ng fraud in the performance of the obligation already existing, already contracted. So, yun ang tandaan natin sa incidental fraud. The example in your book is, I think, bumili siya ng alak, tapos yung dineliver sa kanya is may halong cheap wine, if I'm not mistaken. That is incidental fraud as well. So, yun ang tandaan nyo. Anyway, ang pinag-uusapan sa 1170 is incidental fraud. What you have to remember also about incidental fraud, you cannot annul the contract, but you can only ask for damages because of incidental fraud. So, yun muna ang tandaan natin. How about negligence or fault or culpa? So, napag-aralan natin itong term na to a while ago in quasi-delics. So, hindi ito bagong term. So, negligence, a voluntary act or omission, there being no bad faith or malice. So, nakikita niyo yung pagkakaiba. Fraud, talagang merong intentional na panloloko. In negligence, fault, or culpa, there is no bad faith, no malice, but there is a voluntary act or omission which prevents the normal fulfillment of an obligation. So, pagka naman kasi may negligence tapos may halong bad faith, hindi na yung provisions on fraud will apply. So anyway, yung pangatlo, we will discuss more regarding negligence and fraud later on. Also, take note of legal delay, default, or mora. So, yun ang next na ground for liability. So there are actually two kinds of delay. Remember, yung ordinary delay and the second one is yung ating pinag-uusapan sa provision na to, legal delay, default, or mora. So anyway, ordinary delay is the failure to perform an obligation on time. So meron ka lang obligation and you fail to perform it on the designated time. So yun ang ordinary delay. What you have to remember about ordinary delay is that it is not a source of liability. Hindi ito grounds for liability. Yun ang tandaan nyo. So kung may ordinary delay, hindi magiging liable ang debtor. Yun ang tandaan nyo muna. Now, Also, take note of legal delay, default, or mora. Ito yung pinag-uusapan natin sa provision na to sa 1170. So obviously, legal delay, default, or mora is a ground for liability. So this is the failure to perform an obligation on time, which failure constitutes a breach of the obligation. So again, may time element, failure again to perform on time, but this instance, the failure will constitute a breach of the obligation. So remember, paano nagiging legal delay yung ordinary delay? So, yung ordinary delay, well, hindi yan source of liability, nasabi ko na kanina. Pero yung legal delay, magiging source of liability yan. Now, how do you convert ordinary delay to legal delay? So remember, ordinary delay will be converted to legal delay and magkakaroon ng liability yung debtor from the time the creditor judicially or extrajudicially demands from the debtor the fulfillment of the obligation. So remember, ang nagko-convert sa ordinary delay into legal delay is demand, which may be extrajudicial or judicial. So remember, ang extrajudicial demand is made without the help of the court. Yun namang judicial demand, punta ka sa court, magdemanda ka. That is judicial demand. So, sabi ko nga, walang liability ang ordinary delay. So anyway, mamaya magbibigay ako ng example. Idudugtong natin yan sa fortuitous event so that you will get kung ano yung liability sa mga ito sa apat na grounds for liability. So anyway, there are three kinds of default: mora solvendi, mora accipiendi, and compensatio morae. So mora solvendi is a delay on the legal delay or default on the part of the debtor to fulfill yung obligation. So here, debtor is in delay. So it is mora solvendi ex re in case of real obligation, mora solvendi ex persona, debtor's default in personal obligations. Please take note of the requisites of mora solvendi. Obligation is due and demandable. Failure of the debtor to perform the obligation on the date agreed upon, and demand made by the creditor to the debtor to comply with his obligation. Again, demand may be judicial or extrajudicial unless demand is not required. So, merong exceptions yan, which I will discuss later on. So, yung demand is talagang bayaran mo na. Hindi pwedeng remind, uy, paalala ko lang sa yung ano mo, utang mo, pre, ha? Hindi ganon. Hindi demand yon. Magbayad ka na ng utang mo, pre. Yun ang demand. So, anyway, and number 4 requirement, there must be failure of the debtor to comply with the demand. So, remember, in case of burden of proof, creditor must prove that he or she made a demand. So, also, the debtor must prove that the delay is, that default is not caused by his fault. So, yun ang tandaan nyo, to exempt him from liability. So, pagka nagkaroon ng mora solvendi, remember the debtor will be guilty of breach. Obviously, the debtor will be liable for interest and damages. And even if the object is lost by a fortuitous event, binanggit ko na dati, anyway, pag-aaralan natin ng mas malinaw mamaya, the debtor is still liable. If the obligation, obviously, even if the obligation is to deliver a determinate object. Remember, ang determinate or specific object, pagka nawala yan, nawala na talaga. Kasi nag-iisa lang yan eh. Pero, may liability pa rin yung debtor. So, yun ang tandaan nyo. What else? Mora accipiendi naman, default on the part of the creditor. Paano naman nagde-default ang creditor? Creditor nga siya. Yes, correct. Pero remember here, the default is due to the failure to accept the performance of the obligation. So, nandiyan na, nagbabayad na ayaw pa niyang tanggapin. So, remember here that the refusal must be unjustifiable. So, doon sa time na the performance or payment can be done, hindi niya tinanggap yung performance or payment. So, what are the effects now of mora accipiendi? Obviously, the creditor is guilty of breach of the obligation. Creditor is liable for any damages that will be suffered by the debtor. Kung meron syempre, creditor will bear the risk of loss. So, kung nawala yung object while in the possession of the debtor and the debtor already offered yung already tendered performance, binabayaran na niya binibigay na niya yung object, pero hindi mo tinanggap. Now, if the object will be lost, remember that the creditor will bear the risk of loss. So, if the obligation is to pay for money, tapos pinipilit ng bayaran ng debtor, ayaw tanggapin ng creditor, debtor is no longer liable for interest from the time of the creditor's default, and the debtor may release himself from the obligation by depositing the money in court or other legal authorities. So, ang tawag dun sa pagde-deposit sa money in court is called consignation. Anyway, we will learn consignation when we go to Chapter 4, Section 1. So, the last kind of default is compensatio mori. This is the default in reciprocal obligations. So, the delay of the obligor cancels the delay of the obligee and vice versa. So, because both of the parties are in default, there is no actionable default as if no one is in default. So, the effect is obviously there is the delay of one party. The delay of the parties cancel each other's delay. So, as if there is no default. What else? Kung nasasabi ko yung term na delay, what I mean actually is default, because remember, ordinary delay is not a ground for liability. And also remember here that you will apply the provision in section 1192. So if the delay of one party is followed by that of another, the liability of the first offender shall be equitably tempered or balanced by the court. So if hindi ma-determine kung sino yung unang in delay, the contract shall be deemed extinguished and each party shall bear his own damages. So anyway, we will discuss that later on. So yun ang tandaan nyo muna. However, like I said a while ago, demand is necessary to convert ordinary delay into legal delay, subject to exceptions under 1169. So anyway, when the obligation expressly provides na, pagka araw na kailangang magbayad, hindi ka nagbayad, remember that you are already in default, legal delay, even if I do not demand. So, yun ang agreement between creditor and basta dumating ang June 15, yun ang due date. Kahit na hindi na ako mag-demand, default ka na kaagad. So, obligation is expressly provides. So, dapat clear sa agreement. So, the obligation must expressly declare that demand is not necessary to put the debtor in default or other similar words. What else? When the law provides. So, pagka the obligation is provided by law, yung mga legal obligations, which we already talked about in Chapter 1. Remember, demand is not needed to put the debtor in default. So, pagka nag-due na yung mga taxes, tapos hindi ka pa rin nagbayad, hindi naman kasi nag-demand yung BIR so hindi pa ako default. Hindi totoo yun, class. Demand, there is default even if there is no demand. Yung mga obligation provided by law are due without need for demand. Number 3 is when time is of the essence of a contract. So remember, class, in number 3, the fixing of the time is the controlling motive for the establishment of the contract. So the debtor here, alam niya na kung hindi niya ma-perform within the time required or designated yung obligation, wala nang kwenta ito para sa creditor. So it will no longer benefit the creditor. So remember, hindi naman kailangan na nasa contract na ilagay na time is of the essence of a contract. So intent here is sufficient as long as intention is implied. Like gagawa ka ang obligation mo is to bake a cake para sa isang birthday party. So ang birthday party is, let us say, 2 days from now. So kung hindi mo na deliver yung hindi mo na bake yung cake at hindi mo na i-deliver sa mag-birthday within yung time bago yung birthday niya or mismong birthday niya, hindi mo na i-deliver, remember here that there is already default on the part of the debtor, even if hindi nag-demand yung creditor. Oy, birthday ko na ngayong araw na to, i-deliver mo na. Hindi, common sense yan eh. Kasi dapat i-deliver mo na ngayong araw na to dahil birthday niya ngayong araw na to at the latest. So you have to deliver on the date of the birthday. Even if there is no demand, default ka na kaagad, liable ka for damages here. What else? Demand is useless. So if the debtor has already rendered the obligation beyond his power to perform. So, kung obviously hindi na talaga mapaperform yung obligation, there is already default on the part of the debtor kahit na hindi na mag-demand kasi wala nang kwenta. So anyway, here, ang mga examples niyan is before the due date, the debtor has already sold the thing, na i-deliver niya in favor of another person, or destroyed the thing na dapat niyang i-deliver, or nagtatago na yung debtor. Remember, demand here is useless. Default na kaagad yung debtor. Sira na yung object bago pa ma-deliver, sinira ng debtor. Magde-demand ka ba? Hindi na. Debtor is automatically in default. What else? When there is performance by a party in reciprocal obligations. So, in reciprocal obligations, meron akong obligation sa'yo, may obligation ka sa akin. Like, sasayaw ka, kakanta ako. So, pagka sumayaw ka na, because the obligation is reciprocal, kailangan ko nang kumanta. So, yun ang tandaan natin. Yung performance ng isang party will will automatically put the other party in default. So, yun ang kailangan nating tandaan. So, if the other party performs yung obligation, there is a default on the part of the other party o nag-uumpisa na yung default sa part ng isang party even if there is no demand. Yan. Because the performance serves as the demand. Yeah, sumayo na siya eh. So, obviously, kailangan mo na kumanta. So, yun ang reciprocal obligation. So, yun ang let us remember that when it comes to instances when demand is not needed to put the debtor in default. So the last ground for liability is contravention of the terms of the agreement. So ano na to? Simple violation of the terms and conditions stipulated in the obligation. So here, the contravention of the agreement or violation of the terms of the agreement must not be due to a fortuitous event or force majeure. So please be able to distinguish yung fraud from negligence. So anyway, tutulungan ko naman din kayo. So here, please take note of 1171, responsibility arising from fraud. So sa responsibility arising from fraud, remember, the court is not given the power to mitigate or lessen or reduce the damages to be awarded. So, pagka kasi fraud, remember, it implies, again, deceit, it implies malice. it implies bad faith. It is intentional. So, if there are damages due to the creditor because of fraud, hindi pwedeng i-lessen or i-mitigate ng court yan. So, yun ang tandaan natin sa fraud. So, also, please take note of the rules regarding waiver for fraud. Waiver of an action for future fraud is void. So, pwede mo bang i-waive yung action for future fraud? Parang sabi mo, bago mo palang ako lokohin, ang waiver is pinapatawad mo na yung liability. So, ang example siguro nito is, bago mo palang ako lokohin, pinapatawad na kita. So, hindi pwede yun, class. That is against public policy. You cannot waive the commission of future fraud. So, obviously kasi pagka pinabayaan ng law yan, yung debtor, alam naman niyang hindi siya magiging liable pagka nanloko siya. Eh di, manloloko na siya. So, it will open the floodgates to commission of fraud by the debtor. What else? Number 2, in case of past fraud naman, it can be subject to a valid waiver. So, kung niloko mo ko noon, pwede kitang patawarin. So, this is an act of generosity or magnanimity or kabaitan na lang, sabihin na natin, sa part ng isang creditor who is the victim of fraud. So, here, ang wine-waive dito is not the fraud itself, unlike in number 1. What is waived here is the effect of the fraud that has already been committed. So, yung effect niya is sana damages babayaran, di ba? Wine-waive mo yon. So, the waiver must be expressed in a clear language. So, there is no doubt as to yung intention ng creditor to give up the right to claim damages against the debtor. So, what else? 1172 naman is responsibility arising from negligence. So, kung ang fraud, hindi pwedeng i-reduce ng courts ang liability, remember, in case of negligence, the courts are given wide discretion in fixing the measure for damages. So, kasi nga negligence is dependent upon the circumstances of each case, and hindi naman siya kasing grabe ng fraud. Kasi, remember here, negligence or fault ang cause ng liability. So, hindi naman sinasadya yan. Hindi sinasadyang mag-cause ng injury or damage. So, here, the court may mitigate yung damages to be awarded to the creditor. Please take note also, class, of the kinds of negligence according to source of obligations. There are 3 actually, yung contractual negligence, civil negligence, and also criminal negligence. So, yung una is contractual negligence or culpa contractual. So, here, negligence in contracts resulting in breach. So, the debtor here is liable for damages in view of his negligence in the fulfillment of a pre-existing obligation. So, may pre-existing, may contract, hindi niya na-perform yung obligation niya under the contract. So, yun ang culpa contractual. Yung pangalawa, pinag-aralan na natin to, civil negligence or quasi-delict or torts or culpa aquiliana or obligations ex quasi-delicto or obligations ex quasi-maleficio. So, again here, negligence is the source of obligation between parties who are not related by a pre-existing contractual agreement. So, yun ang tandaan natin. Anyway, this is already the second time that we are dealing with this. And the last one is criminal negligence or culpa criminal. So, negligence resulting in the commission of a crime. So, dahil sa negligent act mo, you committed a crime also. So, let us take, for example, example na lang para madali, yung isang bus, yan. So, ang bus is involved in transportation. Obviously, it is a public utility vehicle. It is a common carrier. So, ang tawag sa lahat ng mga public utility vehicles is also, they are also known as your common carriers. So, common carriers or PUVs have an obligation to exercise extraordinary diligence. Yun ang rule with respect to common carriers. So anyway, sumakay ka ng bus, tapos habang nakasakay ka ng bus, remember class, pagka sumakay kayo sa bus, you are entering into a contract. Not with the driver, but with the bus company. So, yung operator ng bus, yun ang kakontrata mo. Tandaan nyo mabuti yun ha. Wala kayong contract with the conductor or the driver. Kasi mga empleyado lang yung mga yan. Yung contract is entered into between the operator, the bus company, and you. So, passenger ka, sila yung operator. So, anyway, the contract here is to transport passengers from point A to point B, kung saan sila pupunta safely. Yan. So, yan ang obligation. So, obviously, kailangan walang injury, kailangan buhay. Yun ang contract of transportation. Araw-araw you enter into a contract of transportation, hindi nyo lang napapansin. Kahit wala kayong pinipirmahan. Remember, hindi naman lahat ng contracts nakasulat. Pero, ma'am, paano po yung ticket? Tama, sa bagay, yun naman. Anyway, contract din yun. May point kayo doon. Paano kung sumakay kayo ng tricycle? May ticket ba? Wala. Pero here, there's still a contract of transportation. Valid contract pa rin yan, even if not written. So, nakita nyo yung point na yon. So, anyway, passenger ka. So, meron kang contract with the bus company. So, habang nagda-drive ang driver ng bus, very negligently. So, dahil sa sobrang bilis niya, may nasagasaan siya. Dahil nga may nasagasaan siya, ayun, na-aksidente, na disgrasya, bumangga pa siya sa pader, ikaw na passenger, na-injure ka pa. So, anyway, dalawa ang victim here. Sabihin na natin yung nabangga siya is, nabangga siya sa bato, yan, malaking bato. So, merong isang pedestrian na nasagasaan and merong isang passenger na na-injure. So, dalawa yung na-injure niya. So, kung ikaw yung pedestrian, doon na lang tayo sa pedestrian na nasagasaan. Ano ang pwedeng maging, saan ka pwedeng mag-claim? Pwede bang mag-claim ka sa based on contractual negligence? Pwede bang mag-claim ka based on civil negligence or criminal negligence? So, remember, if you are the passenger, you cannot claim, based on contractual negligence. Why? Because you do not have a contract with the bus company. Pedestrian ka nga lang eh. Dumadaan ka lang tapos nasagasaan ka. So, yun ang tandaan natin. So, now, dalawa lang ang choice mo. You can either file an action for damages because of civil negligence or quasi-delict. Dahil nga, negligence here is the source of obligation between the parties not related by a pre-existing contract. Wala namang contract yung pedestrian at saka yung bus company. Nasakaling tumawid ako at dumatakbo kang bus, sasama mo ko, etc. Babayaran mo. Wala namang ganung contract eh. So here, remember, as a passenger, as a pedestrian, because you do not have a pre-existing contract, ang available action to you is not contractual, culpa contractual. But what is available is civil negligence or torts. Yan. Mas ginagamit nila yung term na torts kasi eh. So, quasi-delict or torts. So, here, action for damages. Action for damages in court. You file an action for civil action for damages in court. Now, also, as a pedestrian, you can file a criminal action. Yun yung tinatawag nilang yung mga sa mga pulis tinatawag nilang reckless imprudence resulting to, yung iba resulting in physical injuries. But actually, that is the wrong terminology for the crime. The right term is, let us say, slight physical injuries na lang, nagasgas ka lang. Hindi ka naman na hospital ng matagal. So anyway, let us say the crime is, the injury is minor. So, slight physical injuries. Dapat ang tawag sa the correct term for the crime committed is slight physical injuries through reckless imprudence. Pero, alam niyo naman, nakasanayan na kasi nakasanayan na ng mga pulis yung mali eh. So, wala na tayong magawa. Akala natin yun ang tama, but that is the wrong way to call these kinds of crime. Yung mga imprudence resulting from imprudence na mga crimes, yun talaga ang tawag. Pero kasi kahit sa balita, kasi mali eh. Kaya, hindi mo na makorek. Pero, yun ang tama. At least, again, alam nyo yung tama. So, pwede ka mag-file ng action for criminal negligence, yung slight physical injuries through reckless imprudence. Because here, the negligence of the driver by driving too fast is resulted in the commission of a crime. So, question here is, pagka civil negligence ba, coincidentally, kanino mo ifa-file yan? You can file it against the driver. You can file it also against the bus operator. Yung bus operator, yun nga lang, meron silang defense. They have the defense of diligence in the selection and supervision of the employees. Kung diligent sila sa pagpili ng mga empleyado, qualified, pinapaseminar, etc., hindi mo mahahabol ang bus company. Pero mahabol mo naman yung driver na walang pera. Kawawa naman. Damages nga eh. So pera-pera lang yan. Now, in criminal negligence naman, or culpa criminal, here, ang idedemanda mo rito is yung driver lang. Because obviously, hindi naman yung bus company ang pwedeng maging makulong para dito eh. So, yun ang tandaan nyo. Now, if you are the passenger, obviously, you have a right to file a case for contractual negligence because there is breach of contract here, the contract of transportation. Bring passenger point A to point B unharmed, pero hindi eh, na-injure ka. So, breach of contract, which you can file. Breach of contract is an action again for damages. An action praying for damages. So, nanghingi ka na naman ng danyos. And civil na naman to. So, walang kulong-kulong ito. And this will be filed against the operator of the bus. Because remember, you do not have a contract with the driver. Pwede rin naman siya mag-file ng criminal kung gusto nila. Wala namang problema yun. So, yun ang tandaan natin sa kinds of negligence according to source of obligation. So, pwede kang mamili kung anong i-file mo. So, pwede kang mag-file ng, kung ikaw yung pedestrian coincidentally or culpa criminal. So, even with respect to the same negligent act, isang act lang, pero pwede ka mag-file ng dalawang case. But, pili ka. But what the law prohibits here is the recovery of damages for the same negligent act. So, kung naka-recover ka sa culpa criminal, remember because ang culpa criminal crime yan, di ba? So, tandaan nyo, meron laging civil liability arising from a crime. Dun sa acts or omission punishable by law, remember, may civil liability. Nakaakibat ang bawat crime. Not all. Merong mga crimes na walang civil liability. Pero dito meron. So, anyway, magbabayad ang akusado doon pagka napatunayan guilty siya. Makaka-recover ka doon. Tapos, pwede ka rin maka-recover sa quasi-delict because this is an action for damages. Now, what the law prohibits is, pagka naka-recover ka na sa quasi-delict, magre-recover ka pa ng civil liability sa culpa criminal, bawal yon. Sa isa ka lang pwedeng mag-recover. So, yun ang tandaan natin sa kinds of negligence according to source. Source. Factors to be determined to determine negligence. So, nature of the obligation. So, examples in your book are very on point. So, smoking while carrying materials known to be flammable will constitute negligence. Pero kung nag-yosi ka lang, wala ka namang binubuhat na flammable materials, remember, hindi negligent yan. What else? Circumstances of the person. So, guard, a man in the prime of his life, robust and healthy, sleeping while on duty is negligent. So, kung syempre guard ka eh. So, yun ang trabaho mo, hindi ka naman sakitin, etc. So, negligent yan pagka tutulog-tulog ka sa trabaho mo. Circumstances of time naman, again, driving a car without headlights sa umaga, okay lang yun. Umaga naman eh, nakikita mo naman. But driving a car without headlights sa gabi, that is negligent, obviously. wala ka na nga makikita, hindi ka pa makikita ng mga ibang vehicles. The reason why you use light actually, mas para sa akin mas importante na makita ka ng ibang sasakyan. Kasi kung hindi ka nakikita ng ibang sasakyan, hindi ka talaga nila maiiwasan. Kung ikaw naman nakikita mo sila, maiiwasan mo naman actually Pero kung, 'di ba, hindi mo naman hawak yung brake ng ibang sasakyan. So anyway, ano ba yan? So circumstances of the place, if you drive 100 kilometers per hour dyan sa along TSU yan, negligent yan. Pero mag-drive ka ng 100 sa SETEX, normal lang yun. So circumstances of the place. So remember, yun ang mga factors to determine whether or not a person is negligent. So anyway, please take note also of fortuitous event or acts of God or force majeure or caso fortuito. So any event which cannot be foreseen, or if foreseen, they are inevitable. So it's either impossible to foresee, or if foreseen, impossible to avoid. Fortuitous events are independent of the will of the debtor, and it will make the normal fulfillment of an obligation impossible. So please take note na yung fortuitous event, usually this refers to acts of man. So yung strictly speaking independent, it is an event independent of the will of the debtor but not of other human wills. So war, fire, robbery, murder, yan ang mga fortuitous event. So hindi mo anyway, just take note of that. Yun namang force majeure, strictly those events, they are what you call acts of God. So events which are totally independent of the will of every human. So earthquakes, floods, shipwrecks, lightning, etc., volcanic eruptions, they are force majeure acts of God. So please take note also the requisites. Meron pa yung sa book niyo, ordinary and extraordinary. Please take note of that. So the requisites of a fortuitous event, independent of human will, yun yung mga force majeure. Or if not, it should be at least independent of the will of the debtor. Fortuitous event. Yan. So anyway, the event could not be foreseen. If foreseen, inevitable. Inevitable, naalala ko naman sa COVID, yung Vanessa Hudgens, di ba? May sinabi siya tungkol dun Manood kayo ng balita, ano ba yan? So anyway, the event is of such character as to render it impossible for the debtor to comply with his obligation in a normal manner, and the debtor should not have participated or aggravated the injury to the creditor. So hindi rin negligent dapat ang debtor here. So what are the rules in case of a fortuitous event? So the general rule is that if the object is specific and the same is lost by a fortuitous event, lumindol, tapos bumagsak yung building, yan, nadaganan yung kotse na nakaparada sa harap ng building na bumagsak. So yung specific car na yon, you have to deliver it, debtor ka. But obviously, it is destroyed. So, you cannot anymore deliver it. Kasalanan mo ba yon? Hindi mo kasalanan yon. Anong nangyari? Mayroong force majeure. So, here, the debtor is not responsible for loss or damages caused because caused to another person or to the creditor because of non-performance of the debtor's obligation due to fortuitous event. In other words, the obligation is extinguished. Alam nyo, meron ako mga estudyante, ang dami na. Merong mga estudyante na yung extinguish, they use the word distinguish. Yung distinguish class is differentiate. It is different from extinguish. Yung extinguish class is yung nawala. Alam niyo yung fire extinguisher, anong ginagawa ng fire extinguisher? pinapatay niya yung apoy, di ba? So, extinguish is the root word. Extinguisher nga. So, nawawala yung apoy. Here, nawawala yung obligation. General rule, if the object is lost by a fortuitous event, the obligation is extinguished. Tandaan nyo yun. What else? Exceptions, when the obligation is not extinguished, when it is expressly specified by law. So there are 4 instances when the law states that the obligation is not extinguished. Number 1, if the debtor is guilty of fraud, negligence, or delay or contravention of the tenor of the obligation, yung diniscuss ko kanina. I-rewind nyo kung di nyo na natatandaan. So, again, yung example ko na lang sa delay. Default pala. So, anyway, you are obliged to, mag-example na lang ako sa default pala. So, anyway, let us say, A, anong araw ba ngayon? 23. Today is the 23rd. So, January 23, meron kang obligation contracted today to deliver a horse. Yan. Specific horse na lang. Tomorrow, January 24. So, remember, pagka hindi mo siya na-deliver ng January 24, nakalimutan ng debtor na i-deliver, nakalimutan ng creditor na mag-demand. Remember here, class, that there will be ordinary delay on the part of the debtor. Again, katulad ng sinabi ko kanina, ordinary delay is not a source of obligation. Tandaan niyo yan. So now, noong 24, natapos ang buong 24. So, walang delivery. 25, naalala ng creditor, ay, dapat pala kahapon nag-deliver si debtor ng specific horse. So, anong ginawa ni creditor? Nung 25, nag-demand na siya. So, uy, yung horse, deliver mo na. Dapat kahapon pa yan. So, demand talaga, not a simple reminder. Kasi kung reminder lang yan, it will not put the debtor in default. Uy, remind ko lang sa yung horse. Hindi, class, remember, it should be a clear demand. Deliver mo na yung horse. So, ayan. So, nung nag-demand na yung creditor, yung ordinary delay ng debtor is converted into legal delay. Yan. Tandaan nyo yan. So, bibigyan ko kayo ng dalawang senaryo. What if, class, nung 24 pala, nag-demand siya 25 din. What if nung 24 ng gabi, bigla, kumulog at kumidlat na tamaan ng kidlat yung kabayo namatay. Yan. Oh my God. So, specific kabayo namatay by pagtama ng kidlat. Let us just say, for example, so you cannot deliver anymore the said horse because it's unique. It's a specific horse. So, remember here, class, if lang you will apply the general rule, the obligation is extinguished. Tapos, dahil nga nung 24 pa lang yon, wala pang demand at ordinary delay pa lang. Remember, ang obligation, tama nga, is extinguished. Kasi, yung ordinary delay is not a source of liability. Di naman kasalanan ng debtor Bigla na lang tinamaan ng kidlat, namatay. Now, what if, gabi ng 25, after ng demand is made by the creditor, same scenario, ang kabayo natamaan ng kidlat, again, namatay. Here, because there is already demand from the creditor, there is legal delay or default. Remember, default is a source of liability. Dahil source siya ng liability, the obligation is not extinguished. Siyempre, magtataka kayo. Teka, ma'am/sir. Paano yun? Patay na yung kabayo. Hindi mo na pwedeng i-deliver yan. Kasi sabi mo nga, unique siya. specific, nag-iisa lang siya. Anong i-deliver mo ngayon? Siyempre, not the horse. The horse is dead. But what you will deliver is money because the obligation is converted into a monetary obligation to pay for damages. Yun ang tandaan nyo. So here, the obligation is not extinguished, although technically, the obligation to deliver the specific horse, extinguished na talaga yan. Technical, kung magiging technical tayo. But yung obligation to deliver the horse is converted into an obligation to pay for damages. So, meron pa ring liability. Yun ang ibig kong sabihin dito. Bakit? Kasi may kaakibat na siya na 4 na grounds for liability. So, kapag pumasok na yung 4 na yun, remember, even if the object is lost by a fortuitous event, the debtor is still liable. Basta pumasok niya, kahit isa sa 4 na yan. Remember also. What else? Number 2, debtor is in bad faith. He promised to deliver the same specific object to 2 or more persons who do not have the same interest. Same specific car. Sabi ko, bigay ko sa iyo to A, deliver ko sa iyo bukas. Tapos nakita ko mamaya si B, B, deliver ko to sa'yo bukas, same specific car na pinangako ko rin kay A. So here, debtor is in bad faith. He promised to deliver the same specific object to 2 persons. Remember, paano kung nawala sa yan? Because of a fortuitous event, debtor is still liable. Not only to A, but also to B. Remember. So bakit? Meron kasing bad faith. What else? Obligation to deliver a specific thing arises from a crime. So, yung ninakaw mong kabayo or kalabaw. So, remember yung sa mga crimes, ang unang scope ng civil liability is restitution. So, kailangan mong ibalik. Ma'am, sir, paano hindi ko na nga mabalik kasi namatay na yung specific na animal na ninakaw ko? Again, remember, monetary obligation to pay for damages, reparation of damages. Pwede pang indemnification for consequential damages. So, obligation to deliver a specific thing arises from a crime. So, laging liable yan. Kahit hindi pa kasalanan ng akusado or yung criminal, kasi criminal na arises from a crime. So, kailangang i-deliver pa rin niya yung monetary equivalent ng ninakaw niya. As in my example. And number 4, the thing to be delivered is generic. Remember, generic objects, hindi sila nawawala. Genus never perishes. Genus non quam perit. Kasi pagka nasunog ang isang sakong bigas, maghanap ka lang ng kahit na anong ibang sakong bigas dyan. Pwede na yun. Pareho lang sila. So, hindi nawawala ang generic. So, if you are the debtor, you are obliged to deliver a sack of rice. Eh di, kung nasunog na yung sack of rice na dapat i-deliver mo, palitan mo lang ng iba. So, yun ang tandaan nyo. Genus never perishes. So, the debtor here is always liable. May mga exceptions to. You will learn later on. So, number 2, when declared by stipulation. So, yung basis here for exception is because of the stipulation of the parties. So, yung parties, they agree that even if the loss is because of a fortuitous event, the debtor is still liable. Kahit fortuitous event, mawala yung object na yan. Liable ka pa rin. Yun ang stipulation. So, that will prevail among the parties. What else? When the nature of the obligation requires the assumption of risk. So, this is also known as the doctrine of created risk. So, risk of loss or damage is essential element in the obligation. So, ito yung mga yung mga insurance, remember, yung halimbawa nagpa-insure ka against fire. So, kung walang sunog, may liability ka ba? Kung ikaw yung insurer, ikaw yung nag-insure, wala kang liability. Please take note also class of usury. So anyway, before we go to the term usury, we have to first to define kung ano yung simple loan or mutuum. So sa simple loan or mutuum, one party undertakes to deliver to another money or other consumable thing with the condition that the same amount of money or the same kind and quality of object shall be paid. It may be gratuitous or with a stipulation to pay interest. So in other words, class, ang simple loan or mutuum is known as your utang. So, nangutang kayo ng pera or other consumable thing. Ang ibabayad nyo rin is pera or other consumable thing. There is, it may be gratuitous, ibig sabihin walang interest, or yun nga, it may be with a stipulation to pay for interest. So, in connection with interest, remember, yung usury. So, ang usury is exaction of excessive interest. So, sobra-sobrang interest ang sinisingil mo. Sobra dun sa ceiling, which is allowed by law. Yung usury law, nag-set siya ng ceiling. Ito lang ang interest na pwede, ito lang ang interest na maaari. Pero, ikaw, mas mataas pa dun yung interest na sinisingil mo. That's why it is exaction of excessive interest. So, yan ang concept ng usury at yung usurious interest. So, remember before, a stipulation for payment of usurious interest is void as if there is no stipulation to pay interest. Parang walang interest. Pero obviously, yung utang is still a valid obligation. Yung sobra-sobra or yung usurious interest lang ang hindi pwede. So anyway, what you have to remember about usury is that because of a central bank circular number 905, yung ating usury law ay na-repeal na. So, yung charges on loan or forbearance of money, goods, etc., etc., that may be charged or collected shall not be subject to any ceiling prescribed under the usury law. So, wala na ngayong ceiling para sa interest. So, parties can stipulate now as to the rate of interest, kung magkano ang gusto nila. However, even if the parties are free to agree or stipulate as to the rate of interest, it does not give absolute right to the creditor to charge iniquitous or unconscionable or excessive interest. So, for now, class, wala nang konsepto ng usurious interest. Para sa sobrang laking interest, do not use the term usurious interest because legally, that is inexistent already. Wala nang ganon. Wala nang usury. So, if the interest is very high, unfair na siya, what you can use are the terms iniquitous, unconscionable, excessive. You can also use those terms. So, anyway, please take note, class, that in several Supreme Court cases na nabasa ko, ang interest na 2 to 2.5 to 3%, okay pa yan. Pero anything more than that, especially if the loan is long-term, hindi na pwede. Hindi na pwedeng mas mataas pa doon. So, ang sabi ng Supreme Court, pagka tumaas pa doon sa 3%, I think meron pang 3.5 if I remember correctly. But anything higher than that is already excessive interest. Remember, hindi ginamit yung term na usurious kasi wala nang usury. Excessive interest. Now, remember, before you can recover interest if you are the creditor, there are requisites. Number 1, payment of interest must be expressly agreed upon. May usapan talaga na magbabayad ng interest ang debtor. Number 2, the agreement to pay interest must be in writing. So, kailangan isulat nyo. Now, you have to provide for an interest rate. If ever you do not provide for an interest rate, it is assumed na, presumed that the debtor will be paying for the legal rate of interest, absent any agreement as to the rate. So, may agreement sila na may interest pero nakalimutan pag-usapan kung magkano ang rate, legal rate of interest. Class, dapat malaman nyo kung ano yung legal rate of interest. Hanapin nyo yung circular ng BSP. So, what else? Interest must also be lawful, meaning it should not be excessive interest. Yan. So, yan ang tandaan nyo. Kung hindi nakasulat ang interest, it is not agreed upon. Debtor has no obligation to pay. Creditor has no right to demand payment of interest. Ma'am/sir, ano naman mangyayari pagka excessive ang interest? If the interest is excessive, remember, if you go to court, the court can lessen or reduce yung interest due. So, usually, pagka di ba ang daming nagpapautang, 5%, ganyan. Pagka nagdemanda sila, tingnan nyo, bababa yung interest. Kasi bawal nga yung ganun kalaking interest, excessive na sila. Please take note of the term presumption. So remember, presumption is an inference of a fact na hindi mo naman talaga alam, but because of usual connection with proven facts, pwede mo nang i-assume na ito ay totoo. So yun ang presumption. You will consider as a fact something that you do not actually know. Pero kasi kung i-connect mo siya sa things which you already know or things which are already proven, pwede mong gawin yung mapapatunayan mo na itong bagay na hindi mo naman talaga masyadong alam is also a fact. So yun ang presumption. Please take note also of the two kinds of presumption, conclusive presumption and also yung isa disputable or rebuttable presumption. So yung conclusive presumption cannot be contradicted, like the presumption that everyone is supposed to know the law. So conclusive presumption yan. Remember in Article 3 of the Civil Code, ignorance of the law excuses no one from compliance therewith. So yun ang tandaan natin. This is conclusive. Hindi natin pwedeng i-contradict to. Kahit na hindi mo talaga alam, this is conclusively presumed upon you that you know the provisions of law. Yun namang disputable or rebuttable presumption can be contradicted or rebutted by presenting proof to the contrary. Anyway, this will be explained by the presumption provided for sa article na to. So anyway, in 11, kasing article ito, medyo mahina tayo sa articles class eh. So 1176, two presumptions dito sa provision na to. Kaya natin pinag-aralan yung kinds of presumption at saka term of presumption. So, receipt of the principal by the creditor will give rise to a presumption that interest has been paid. Kasi pagka nagbayad ka, tapos yung bayad mo ay hindi naman buo, tapos may interest pa yung utang mo. Pagka nagbayad ka ng partial, ang presumption is that you are paying the interest. Now, kung bayad mo na yung interest, dun palang i-apply sa principal yung amount being paid. So, kung nag-issue ang creditor ng receipt for the principal, there is a presumption that all interests have already been paid. So, this is, remember, this happens when the creditor does not make any reservation with respect to interest. Hindi niya sinabing, yung reservation is yung, may interest pa. So, yun ang tandaan nyo. Kung wala siyang sinabing may interest pang due, the presumption is that all interest payments have been made. Number 2, receipt of a latter installment of a debt without reservation. Again, as to prior installments, will raise the presumption that prior installments have been paid. So, January, February, March, ito ang mga installments na babayaran mo. Creditor issues a receipt for March installment. So, the presumption is that January and February have already been paid, yung mga installment para doon. Now, if the creditor makes a reservation, nag-issue siya ng resibo for March installment, pero sabi niya, hindi pa bayad ang January and February, remember, the presumption will not apply. So, obviously, these presumptions are rebuttable or disputable presumptions. Pwedeng patunayan na hindi totoo to. So, exceptions to the presumptions. In these cases, the presumptions do not apply when there is a reservation as to interest. Katulad ng sinabi ko na kanina, principal, bayad na, ito yung resibo, pero meron ka pang hindi na babayaran na interest. And, yun nga, resibo para sa interest sa March, pero meron kang reservation as to interest payments for January and February. So, reservation may be in writing, may be made verbally. Number 2, receipt without any indication of a particular installment paid. So, kung meron lang nilagay na may binigay lang na resibo na bayad ng installment. So, there is no presumption na made that all previous installments have been paid already. So, nilagay lang na receipt is for, the receipt is dated March. So, hindi naman sinabi kung anong particular installment ang binabayaran mo. There is no presumption that all previous installments have been paid. Number 2, receipt for part of the principal. So, nag-issue ang creditor ng resibo for a portion of the principal. So here, remember, the creditor waives his right to apply payment first to the interest and then to the principal. So the presumption does not apply na bayad na lahat ng interest. Ang wini-waive lang dito is right to apply yung payment to the interest first before the principal. So kung ang resibo is for the principal, full payment, dun lang naman nagkakaroon ng presumption that all interest payments have been made. Payment of taxes, bayad kayo ng taxes ng 2020, it does not follow na all taxes before 2020 have already been paid. Hindi ito. It doesn't work that way para sa taxes. So, non-payment is proven. Obviously, the presumption cannot prevail against a proven fact. Na-prove nyo na hindi nyo talaga na-prove ng creditor na hindi talaga nabayaran ang mga previous installments, even if yung March installment ang may resibo, kung napatunayan naman ng creditor na hindi naman talaga bayad yung January and February, the presumption will not apply. So remedies, we already studied this. So in passing, specific performance for specific real obligations, for personal obligations, substituted performance, pursue the leviable property of the debtor. So ito ang mga attachment. So properties which are not exempt from attachment. Yung attachment, yun yung parang kino-confiscate ng court or hinahawakan muna ng court, yun, that is the better term, yung property ng debtor to be later used for the payment of his debts if napatunayan na siya ay may utang talaga. So anyway, exercise all rights, like the right to redeem and bring all actions of the debtor, like the right to collect from the debtor of his debtor. So kung creditor ka, may debtor ka, yung debtor mo, meron siyang debtor, pwede mong directly singilin yung debtor ng debtor mo. Ang tawag dyan ay action subrogatoria. So anyway, pwede nating pag-aralan yan later on. What else? Ask the court to rescind or impugn acts or contracts which are intended to defraud the creditor. So ito yung rescissory action or action poliana, which is also a remedy available. So anyway, we will study rescissory actions or yung poliana when we go to contracts. So yun ang tandaan muna natin. Also, please take note also of the rules in case of transmissibility of rights. Remember, the general rule is all rights are transmissible. So, pwedeng maipasa ang mga rights acquired because of an obligation except when it is prohibited by law, like in rights in a partnership, in agency, comodatum, which are purely personal in character. So, sa partnership, kung partner ka sa isang partnership, pagka namatay ka, hindi pwedeng mamana yung pagka-partner mo sa partnership ng mga anak mo pagka namatay ka o mga tagapagmana mo. It is not a transmissible right. Number 2, if it is prohibited by stipulation of the parties, here there is an agreement na bawal, na hindi transmissible yung mga rights. So, after the death of of either of the parties or both, hindi na yung obligation will be extinguished. Hindi na maipapasa sa heirs, hindi pwedeng i-assign sa another person. So, because this is contrary to the general rule, this must be clearly proven. So, that is what you have to remember about transmissibility of rights. General rule as opposed to yung exceptions by law and by stipulation. Anyway, that is a very long chapter, I understand. So, I hope matapos ninyo. Alam niyo naman ang mga views. Nakikita ko naman ang statistics eh. So, anyway, you have all the resources. Nasa inyo na lang kung gagamitin ninyo. So, that's it for Chapter 2, Nature and Effects. Our next topic will be Chapter 3, Section 1, Pure and Conditional Obligations. Thank you, class, and good night.